Welcome to the Investor Empowerment Series radio show, empowering your real estate investing with techniques, opportunities, and information, minus the BS and sales pitches. Now, please welcome the host of the Investor Empowerment Series, Joe Mueller, from the Tough as Nails Investment Syndicate. Joe Mueller.
This is the Investor Empowerment Series radio show, episode number 22, with Chris Emerald of CE Law. Awesome episode about asset protection, estate planning, and representing real estate investors, aka you. Don't miss it. Keep listening. All right. So, Chris, next week we've got you at the Investor Empowerment Series meetup at the Westwood in Schaumburg. I'm totally pumped to have you there because I know you're going to provide a ton of great information to our investors. This podcast is actually going to get released that night, which I think is kind of cool. So for the attendees of the meetup or anyone listening to this now, Chris is going to be speaking on the 29th, which you're probably going to be listening to this after November 29th. But I'd like to kind of cover some of the topics that you're going to talk about during that meeting for the individuals that maybe couldn't make it or want to get some more follow-up information on you.
Okay. My name is Chris Emerald, and my firm is CE Law. My office is in Lake in the Hills, and it's my pleasure to support the meetup group that's been meeting in the Westwood out in Schaumburg for about, the last year or so?
Yep.
Been doing that?
Yep, and that's Schaumburg, Illinois, and Chris is based in Lake in the Hills, Illinois, for the listeners out of the area. Yeah, it's actually been officially 1 year, which is awesome. I'm very happy about the results of that meetup, and kind of started it to see what would happen out there at that location, and I think it's been good.
Yeah, kind of a happy accident to find that, right?
Happy accident, yes. Let's talk a little bit about your experience or what you offer when you're working with a real estate investor who maybe needs to, I know you do business startup and consultation. I know you do asset protection type consultation, estate planning, things like that. Let's just kind of get into what Chris Emerald's all about when an investor-client comes to the table.
Okay. So most of my practice centers on three main areas. One is going to be small business to mid-sized business, forming entities, structuring entities that leads into how do you structure, business entities for the real estate investor, which is specific for our purposes at the meetup at the Westwood. The other thing that I do spend a lot of time on is estate planning, probate, and trust work. So that's the planning for, what happens if you can't make decisions for yourself, either medical decisions or property decisions, managing your estate, typically through living trusts and other means, and then disposing of estates when people eventually pass away. The remainder of my practice then focuses on real estate and transactions. So that then, runs the gamut from helping people buy their very first house. It's very rewarding to talk to, young kids that are 24, 25 years old and gotten out of college and, just got their first decent job and are looking at buying a house or a condo, a townhome, whatever it is, all the way through, commercial transactions, buying and selling properties that are going to be used for everything from, commercial purposes, large national chain stores, whatever. But, most of the stuff that I do is with small investors that are buying and selling properties, rehabbing them, wholesaling properties, whether or not they're going to buy and hold for, a portfolio of rental properties or they're just fixing and flipping. So, lots of experience with that and how to structure everything from how you hold the property to how you document money that you borrow for rehabbing a property to how you hold a property long term, if that's what your goal is for a rental portfolio.
So one of the reasons why I work with you personally in my own business and real estate investing, you brought up, you just touched on it, which is a large gamut of attorneys that I've interacted with through my investing career. Not a lot of them seem to even understand how a wholesale transaction is supposed to work, right?
That's true. You know, we both know people that wholesale on a fairly regular basis, and a lot of what happens between your office and my office when we work with a client that's wholesaling a property is understanding the transaction, getting the ultimate buyer and the seller to understand the nature of the transaction.
Right.
You know, quite often, you know, our offices are able to kind of get people comfortable with the concept. And, you know, sometimes we're not. And that quite often comes down to the fact that a buyer's attorney is uncomfortable with just the very nature of the transaction. Sometimes a buyer or a seller's attorney will be uncomfortable with the idea of the wholesaling transaction as a whole and not seeing the value of the wholesaler and what they're doing and the value and how that translates into a profit for the wholesaler in being able to put together people, whatever, an ultimate buyer and an ultimate seller for that, and then working with your office on marketing properties and everything, and all the work that goes along with that for them. But quite often, you're absolutely right. The attorneys just, you know, their head explodes when they realize, and some of the issues, whatever that initially come up, are things like, you know, if you send a title insurance commitment to a buyer's attorney, and they immediately do, you know, what they're supposed to do and see whether or not the contract matches the title insurance commitment. And when it doesn't, then there's some explaining to do.
Sure.
How that's all going to work. And, you know, what is my client actually buying? And, you know, what's going to happen then? And what's the difference between the sale price or whatever on the first contract with the sale price on the second contract? And, you know, the way that...
And we're talking specifically regarding a wholesale.
This is all wholesaling right now, whatever, and getting people to be comfortable with the nature of that transaction. So that's a reasonable part of what I've been doing, whatever the last 6-7 months. In everything, and certainly your office has as well. And a lot of it is trying to meet client expectations. And so with a wholesaling transaction in particular, you're involving at least one other party than you normally would. And as far as complications go, that's not a linear equation. You know, add one more person, add 1/3 more, you know, or 1/4 more complication, whatever. Usually it's exponentially hard or whatever, because you're trying to balance out everybody's expectations for that. So just as an example, as we were talking about trying to give some anecdotal evidence, you know, both of our offices just worked on a transaction that we had hoped would close last week. And that took, you know, everybody kind of coordinating, one person in one office for the title company, another person in another office for the title company. So instead of having, you know, everybody sit down in one location and work things out, because of the number of parties involved, we just weren't able to get everybody in one room.
Right.
And so that means that we've got to have a good relationship with the title company that's willing to do that for us. We've got to communicate properly with that. Now, ultimately, that transaction didn't close on, you know, last week or whatever, but that's because of items and issues outside of the planning that was done in order to make sure that all the I's are dotted and the T's are crossed. So again, when you add the extra parties, you add more, not just one level of, or one layer of complexity on that.
So not to cut you off, but let's take a step back and just, so for the listeners to understand what you're saying as far as the level of involvement that you have in some of these transactions and how we work together, and ultimately why you're on the podcast and you sponsor the meetup and you're, you know, part of my real estate business. Chris is the type of guy that understands what needs to happen from an A to B to a B to C type transaction when you're talking about representing not only a buyer or a seller, but also on a wholesale level. So I brought Chris in to some of the transactions that we're representing as a broker, because we've actually got wholesalers in our client database that are listing properties through my company, Tanis Group, on the MLS, a little more outside the box than what most wholesalers are doing. And he's actually representing those wholesalers as an attorney and ensuring that that property or that opportunity gets from the start to the finish, and that wholesaler gets a check at the end, which, again, back to my original question, it's pretty rare, honestly.
No, I agree.
Not
I
a lot of
agree
attorneys are willing to be involved in it.
And certainly, we've had transactions fall apart because the other parties aren't willing to cooperate, which ultimately comes down, there's the wholesale transactions, and then there's, different transactions that real estate investors, especially newer real estate investors, will get some education or information about, in particular like subject to transactions, whatever, which I'm much more leery about than wholesaling transactions, where everybody has to cooperate and go in with their eyes wide open. If people who are entering into these types of transactions don't understand the transaction itself and the character and nature of it, and understand it and are open to it, then you're going to have problems. That's exactly what happens when an attorney gets a hold of a contract and thinks that they're going to put it into the box that they're used to grinding day in and day out.
Right, sure.
That's typically what's going to cause a problem. Illinois, whatever, if people don't understand or they're listening outside of, the Chicago area, Illinois is a reasonably rare jurisdiction where we have real estate attorneys involved in pretty much every transaction.
Right.
Or at least they should be.
Right.
Chicago and Collier counties in particular, the market is complex enough. And we have some case precedent and things like that forces the involvement of attorneys in real estate transactions that I won't get into. But it's become, part of the real estate landscape in this area that we have real estate attorneys. And attorneys, excellent attorneys, base their practices about, the residential real estate transaction. And even specialties within, the marketplace that they have. They build up a clientele, whatever, that do specific things, whether or not it's brokers that are making referrals or whatever. I think, one of the unique things, whatever, that I understand, I've just dealt with enough of the jurisdictions in and around the Collier counties that I'm reasonably comfortable with dealing with properties in Lake, McHenry, Kane, Will, DuPage, Cook County,
sure,
everything. So that covers a pretty wide area, throws a pretty wide net.
Right.
A lot of the issues, whatever, that we have with transactions, whether or not they're normal transactions or wholesaling transactions, are the municipal requirements. That can be, the stumbling block for the transaction in and of itself.
Transfer stamps, water bills.
Transfer stamps, water bills, all the rest of that. Down in the city of Chicago, you've got, whether or not you need a zoning certificate.
Sure.
Whether or not you need a building registration. Whether or not you've got a full payment certificate for the water. Whether or not you do certain things, whatever. And so that jurisdiction in particular poses challenges. Timing, as far as how long it takes to close a transaction, et cetera, those huge things. And so you've got to be on top of that and be familiar with that. Other jurisdictions in the area, whatever, have their own quirks and requirements. And so you need to take a look at all of those requirements and understand the environment that you're in. Because, a local transfer stamp, you can't close.
Right.
Nobody in their right mind would take subject to. The title company won't handle it and close on it, disperse the funds, et cetera, whatever. So without those things, you're just not going to close. And, knock on wood, I've been fairly successful over my career with being able to manage those kind of things. But ultimately, a lot of it comes down to being able to establish a relationship with both your client and the other parties. Mm-hmm. Cooperative working relationship. And that's the case whether or not you're just dealing with an A to B transaction or whether or not you're dealing with a wholesale transaction or a subject to transaction or whatever.
So you brought up a few things that I want to clarify real quick. When he mentions Collier counties, for the listeners that are not in Illinois or in the Chicago area, for example, Chicago is in Cook County, Illinois, and it's a 7-county area. When he says Collier County, he means the counties that surround the city of Chicago and Cook County, essentially. So it's that big northeast section of Illinois, if you're looking at a map, is essentially what he's referring to. That's where the bulk of the transactions probably occur in Illinois based on the population and, the sheer fact of demand and supply and demand. There you go. Because the main population of Illinois obviously resides in these counties. Second part is, you mentioned it a few times, and I think this would be a great learning point for the listener, is you brought up subject to. And I don't think that's something we've really touched on the podcast yet. And I'll give you my layman's term explanation of what a subject to is, and maybe you can elaborate on that a little bit. But my understanding, for those who haven't heard it before or are learning more about what a subject to is, the term itself, subject to, stands for subject to the existing mortgage on a property. So if we walk through that type of a transaction, that basically means you're going to purchase a property from a homeowner that has an existing first and or second lien or mortgage on that property, and you're going to buy it subject to the existence of those liens. And to simplify that, that means maybe you're going to take deed or title to a property, but still be responsible for those mortgages. So, for example, I buy a property with a $100,000 mortgage on it, subject to the existing mortgage, and let's say I can rent that property out for, $1,500 a month, and the mortgage payment is $500 a month. So there's a spread in between there that I'm taking, there's my profit margin as an investor, but that loan is still in the name of the original homeowner, and I'm just taking title to it. Now, I don't want to get into assumption of mortgages or due on sale clauses or what kind of occurs, unless you want to elaborate on because you said you were leery of subject to. And I used to do subject tos back in the early 2000s. I pretty consistently was deeding properties into my name from homeowners that were in foreclosure. I was bringing the balances owed back current again, and then making payments on that mortgage, and then selling those properties. That was pretty much another life for me over 10 years ago. But why are you leery of a subject to? If the opportunity's there, what's the real risk for both parties?
Well, certainly, for some of the things that you mentioned. First of all, wherever you're at and you're listening to this, you should consult with an attorney and see whether or not the subject to type transaction is even legal in your jurisdiction.
Is it legal anywhere?
There are jurisdictions, where it's not permitted.
Really?
Yes.
See, now that's something that they won't tell you at a boot camp, I'm sure.
Yes.
Really?
And so the other issue that I have with subject to transactions, obviously you've got an original seller. If I'm representing a client that's trying to take title on a subject to transaction.
So you're representing the investor.
Correct.
Who's working with a homeowner and completing the purchase transaction.
Correct.
Okay.
Correct.
Who's got a loan on it. So.
Yeah, correct. And so, there are a couple of ways that we can do that typical type of transaction. The difficulty that I have is that those types of transactions have a huge opportunity for an investor to take advantage of somebody who doesn't have equal bargaining power. So the typical scenario that you will see is that somebody is looking to sell a property, and those people and or the property in and of itself is subject to some distress. So this is, the little old lady or the widower or the people who inherited the property from grandma or grandpa that can't pay the taxes, they're getting kicked out of the property, etc. And so the perception that's often associated with a subject to transaction is the big bad wolf type investor that's coming to take advantage of someone. When we deal with attorneys having objections to wholesaling transactions and the level of complexity and resistance you'll get to those transactions, as a seller's attorney in those types of transactions, you're going to run into that resistance, doubled, tripled, because the way that transaction has typically been structured is that there's a deed recorded, a quitclaim deed, subject to taxes and existing liens, etc.
And a quitclaim deed is basically the least amount, or what's the best word for it, but the least valuable or representative.
Right, so there are no warranties given. I quitclaim whatever interest I have in the property. So, for example, I could quitclaim my interest in the Brooklyn Bridge to you.
Right.
Whatever you're willing to pay for it. I have no interest in the Brooklyn Bridge. Right, but it's, whatever you take subject to any of the liens or defects on the title, etc. That's essentially what a quitclaim deed is. Warranty deeds, whatever, very different that you'll see. Whatever people that are receiving a warranty deed are receiving title subject to warranty. So if misrepresentations are made through the sale, then you have recourse for that.
So there's no representation or warranty on it. So it's kind of like buying brand new appliances at Home Depot, and with a full warranty if you're using a warranty deed, but a quitclaim, maybe you end up with a stove, but you're not even sure how old it is or if there's any value.
Yeah,
to it.
I mean this is the real estate equivalent of caveat emptor. If you remember your Latin from high school, which is buyer beware. Yeah, right. So
sure.
Is it buyer beware, whatever? Yeah, are you sure you got what you think you have, kind of thing? But we digress.
Least valuable. No, but I think that's a good topic. I mean, deeds are a part of every transaction. So.
Yeah. That being said, of course, and then certainly you're dealing with the issue of whoever the seller is, there's a certain risk involved for them, and you touched on at least one of them, which is the due on sales clause for the mortgage.
Right.
So, a lender never wants the title to the property to be separated from responsibility to pay the mortgage. Okay? And that certainly, there's certainly a risk of that. As long as the investor pays the note, typically my experience is the bank doesn't care as long as the check cashes. Right?
One would think, yes.
And all. When they don't receive the check and they have to start foreclosure proceedings, and then they find out that the owner has engaged in that transaction, now certainly the investor, the current title holder, whatever, they're going to get sued for the mortgage foreclosure and all the rest of it. And so there are additional consequences, in that litigation. Quite often what happens is, and the risk that the seller runs, is that they sell the property subject to the existing mortgage, and then they move. And they think that they've sold the property and that you're responsible for the mortgage as the investor, which technically you are. The problem comes when the investor doesn't live up to their responsibilities. And so
which is a huge risk for the seller.
Which is a huge risk for the seller, in that investors don't buy properties typically subject to for the purpose of moving into them and living them as their primary residence. It's an investment property then. So they have every intention of moving in somebody that's going to take a lease option, or engage in some transaction to buy the property and take title to it when they can pay for the property in full and all the rest of that. If those people who occupy the house or whatever property it is don't follow through, then the question is whether or not the investor honors their part of the transaction that they have with the original seller. And so, quite typically what we see is that the investors don't have the wherewithal or the honor to actually, perform on their part of the transaction.
And that's a great point, because I think taking I think this is a very well-marketed investment plan for like a newer investor, no money down, get this opportunity, make a couple $100 a month, right? Subject to a property, get a property subject to, lease option it, collect, I think they call it a sandwich lease option, but keep that income in the middle. So if you're, if you've got this opportunity and you get it just at the mortgage amount of $500 a month, and then you lease option it out at $1,000 a month, you're getting the $500, plus you're getting the difference between whatever's owed, or whatever amount you agreed to with that seller that you took title to or from. I said that wrong. You took title from, and then the new buyer who's on a lease option, let's say that's an extra $20,000 or $30,000. I mean, you're basically saying that.
Sure. So that's the equity, The profit, whatever, on the buy versus its ultimate sale price, just delayed. And so you're essentially getting into that transaction as an investor for the income stream, right? Mm-hmm. And then you're deferring or delaying the profit, the profit on the actual sale and liquidation of the property. Which is fine, because what's the typical term going to be? 2 years, 3 years, something like that. Whatever. So you say, hey, if I build up an inventory of these properties, 6, 7, 8, 9 properties, whatever you're going to do, and you're taking $400 or $500 a month. Yeah. Okay, well, there's some good money, whatever, and then 2 years down the road, hey, I'm going to make $20,000 on that. Right. Well, now I take that, and you start building up the nest egg, and that's how you do it. The problem comes for everyone,
which is what I want to touch on. Yeah.
Yeah. The problem comes for everyone when the people who are moving into the property and have got the lease option essentially can't perform. So whether you're putting people into those properties that have had credit problems, things like that. And so can they repair their credit and qualify for a mortgage or buy the house within the 2 years, 3 years, whatever period of time that you've got? That's the big question.
Right.
So, and then if that doesn't happen, what does the investor do? Do they move somebody else in there? What do they do?
Do they continue to make the payments?
Could they continue to make the payments even though they're not getting paid anymore or whatever? So that's a huge issue. The other way that we can work with those types of transactions is something that I actually prefer, which is the Articles of Agreement for Deed transaction. Okay. That you'll get a lot more cooperation out of sellers and buyers' attorneys when you're able to work that out. Now, you can kind of wholesale those transactions and things like that. That gets a little bit more complicated. I think we want to get into in the podcast.
Sure.
But an Articles of Agreement for Deed transaction certainly has some of the elements of a subject to transaction, but instead of the seller deeding the property over essentially on day one, the property, what happens is you have a contract. So typically in our area, a 6.1 multi-board contract, okay, with the equivalent of a rider or an addendum to it. That's the Articles of Agreement for Deed agreement.
And this is between the investor and the seller, the homeowner.
Correct. And so then what you have is something where the transaction documents, including the deed and title to the property, remain in the name of the original seller until such time as the buyer can perform fully on the contract.
Which buyer?
It doesn't matter. So your investor or whoever they put in the house. So if the ultimate buyer that the investor puts in is going to perform, then obviously the investor can perform on that, and that's when they would do that.
Understood.
So, but what happens with that is all the transaction documents are escrowed or held essentially in trust by one of the attorneys, and so they're not authorized to go and record the deed unless and until the transaction is performed fully.
Right.
You think so that protects the seller.
The original seller.
The original seller. And so you get a lot more cooperation from the attorney. The downside for that is because you're adding a layer of complexity on top of just a contract, then the original upfront cost is more significant for the investor in that respect.
You got to draft all the articles.
Right. And so we do typically what I say, put 2 attorneys in a room and get 3 opinions. So we go back and forth and we negotiate the terms. And we're all just trying to protect our clients and make sure that the client goes into the transaction with their eyes wide open. They understand they have as much protection in the transaction as is reasonable. No transaction is perfect,
right?
Where both sides are completely protected. Whatever this, everybody's got risk involved in a transaction. Everybody's got risk involved in a normal sale or a subject to transaction, certainly, or a wholesaling deal. Whatever it is, there's risk on both sides. It's a practice in mitigating risk is what you're doing. So everybody walks away a little bit upset and mostly happy. Right, is what you're hoping for in a lot of respects. So that being said, but then in those types of transactions you don't run into the potential violation of a due on sale clause, or a definite violation of a due on sale clause in a mortgage, and potentially having what I refer to as a little blue-haired old lady getting taken advantage, things like that. You're also typically providing title insurance and disclosing everything on our articles of agreement for deed transaction. I would suggest doing that on a subject to transaction no matter what. And in some respects, I think that the disclosures that I typically demand on subject to transactions is equal to the articles of agreement transaction, because I don't want anybody to come back and say, you didn't tell me about this, or you didn't tell me about that,
right.
What the risks, are of that transaction. And then includes providing a title insurance commitment for that. So ultimately,
makes it a legitimate transaction.
Ultimately, the buyer has to know, where did that property come from, who owned it, and how did the person I think I'm buying it from get title to the property, and what's their claim in it. And then when I follow through on the transaction, this is going to be my home, because that's ultimately what most of these transactions are dealing with, is you're putting somebody who's been credit challenged, into a home that they're going to own.
Mm-hmm.
How do they know that they're going to have good title to the property?
Right.
That they haven't paid for a number of years, and then find out that they don't really own the property.
Right, because there could be some lien that's been on title for years. It's been looming over them, and they had no idea.
Exactly. And so I've had transactions where I started working with an investor who wanted to do subject to transaction, and eventually just said, look, you need to go someplace else, because you don't want to provide these kinds of protections because it costs you money.
Right.
And look, my opinion is this: if you're going to make $500 or $600 a month over a period of years, and maybe $20,000, $30,000 on a property, then if you can't spend a couple $1,000s on a title insurance commitment for people, whatever, and an attorney's bill, to make sure that it's documented properly and that you're protected as an investor and the other people are protected, so you avoid the litigation, or a potential litigation afterwards, then you're just not somebody that I want to work with as a client.
Sure.
And so I've withdrawn before, whatever, when I've seen those kind of things, thanks, but no thanks. It's not worth my time and effort, to deal with people like that. And that's a warning to anybody that's out there as an investor. You should either be sufficiently educated and savvy enough individually that you feel comfortable with following through on a transaction on your own, or that you get legal representation, or at least consult with an attorney, so that you understand the transaction. Because the biggest thing that you deal with as an investor is, what do I not know? Right. And so, no attorney will tell you that they know everything. There's a very, very...
Are you sure?
Very, very, many attorneys out there that who are excellent attorneys and very, very skilled in representing clients and know the law and how transactions work and things like that, whatever. But nobody really can honestly say that they know everything.
Sure.
Because there are certain aspects of the law that aren't settled. And so, if somebody knew everything and there wasn't anything that was unsettled anymore, there'd be no point in litigation.
Right.
Or at least you'd certainly, minimize the need for any kind of litigation. That being said, think of the attorney as not just a necessary evil, but, somebody that's kind of a trusted advisor and ally that's going to potentially bring issues up for you, raise questions, and say, hey, maybe I think you shouldn't do this.
Right.
Or, do you understand the risk? My personal opinion is, there's sometimes when I'll tell somebody, don't do that. There are sometimes when I tell people, you need to do this, and then they don't, that to me is job security. They go out and do what they're going to do anyway, and then ask me to help fix it afterwards. I've got my T-shirt that says, I told you so. I'm perfectly happy to meet with somebody wear the T-shirt every once in a while. Hopefully that, a lesson learned on those kind of things. But, the attorney or whatever, with the number of transactions that we typically deal with, you just see enough out there in the world that by sheer level of experience and number of transactions that you recognize issues and you know how to deal with it and recognize the issue, find a solution for it.
Sure.
And then advise the client. And if the client's willing to take the risk and they understand what the actual risk is, et cetera, my opinion is, you're all big boys and girls out there if you're going to be real estate investors. And so the risk that you understand is a risk that you take, willingly. A risk that you don't understand, you didn't know was out there, is something that potentially would cost you, a property or all the profit.
Sure.
On a property.
So
those are huge issues, whatever, for clients.
Before we change gears into another topic, very detailed explanation of what we just discussed. I really appreciate all that information. I think our listeners are going to get great value out of what you're saying. Maybe though, let's I shouldn't say dumb it down, but what is an article of agreement for deed? Before we go any further, because I think we mentioned it a few times. Subject 2, we kind of touched on. Let's do that. Let's tell the listener what an article of agreement for deed actually is and how that'll work, and just a simplified, layman type version in case they don't even know what it is, because you hear it, but they might not know what it is.
Okay. So shame on me for not explaining it to begin with.
It's fine.
So an article of agreement for deed transaction is essentially where you enter into some form of standard board form contract. In our area here in northeastern Illinois, we have several different board form type contracts, either from Chicago Board of Realtors or the multi-board here. We're using what we refer to as the 6.1 contract right now. We take that and then we add an additional agreement on top of that describes terms outside the norm for the board form contract. Typically, the board form contract will specify all the terms such as price and real estate tax prorations and mortgage contingency dates and all of that. So that's your typical A to B. We're supposed to be done in 6 to 8 weeks or somewhere thereabouts for a transaction, whatever you guys agree to or the parties agree to. The articles of agreement for deed then adds a layer of complexity of saying we essentially have an agreement to sell the property at some point in the future. The seller is not allowed to place any other liens on the property or remortgage the property, things like that. Price is already agreed on. A time that the buyer, the investor, has to close the transaction and actually take title to the transaction is agreed upon, as well as a bunch of other terms. So who's going to insure the property and what insurance has to be there? Who gets the right to take the real estate tax deduction for the property? All of those kind of things are dealt with in that articles of agreement for deed agreement.
What's typical on that real estate tax deduction side?
Quite often, whatever the people who are taking possession of the house get the right to take the tax deduction. They do then have to get insurance,
right? Of course.
They have to insure the property. Typically, you would have the homeowner, the original seller, continue to maintain their insurance, and quite typically you'll get a reciprocal agreement to name the buyer and the seller as additional insureds on their insurance policies.
Okay,
things like that. And so, but most of the time that I see that the right to take the real estate tax deduction goes to the buyer, although that's up for negotiation. Typically, then you're setting a payment on a monthly basis, plus the buyer is going to take responsibility for paying the real estate taxes. So if they're responsible for making the payment, then they get the real estate tax deduction. One of the risks for the seller is that if the real estate tax bill is the responsibility of the buyer, how does that get paid? Mm-hmm. So a typical way that we'll deal with that is to have a monthly escrow amount, which would be essentially the equivalent of setting up a real estate tax escrow through your mortgage lender.
Sure.
saying, we'll reprorate the taxes based on what the bill actually comes out, and you're going to pay the equivalent of principal and interest plus insurance, et cetera, and then tax escrow. So your final payment, to the people who are occupying the property as the contract buyers is different than just what the principal and interest would be. So that would mean because the buyers are paying that escrow every month that they get the benefit of the tax.
Sure.
Escrow.
Good.
You can work that out, whatever, it's just a gross payment instead, and then the owners are responsible for it. I don't see that as much, but the beauty, as far as I'm concerned, with the Articles of Agreement transaction is that while standard form type templates for that, transaction exist and attorneys can be familiar with them, then they can be modified. So we can agree on anything between us, but we do have a form to start working off. So this is the same thing, whatever is your 6.1 contract that you're so familiar with in working with it within this area as a broker, right? To put it in colloquial terms, the machine likes to be fed what the machine likes to be fed. So if I, as a broker or an attorney, see a 6.1 contract, we work with them enough where we go, paragraph 8 is this, paragraph 9 is this, paragraph 10 is that, whatever. And so we look for the things that we want to see. And it's easy to review. And we learn what the basic terms and the boilerplate and the fine print are in those contracts.
Absolutely.
So we have some place to work with, and we're to use another phrase or whatever, you're talking the same language.
Right.
At that point, right? So, again, with Articles of Agreement for Deed, there are agreements and templates that are out there that have been approved by bar associations, et cetera, that we can start with. This is a great point where we're coming all the way back full circle with people that aren't familiar with wholesale transactions. You can find real estate attorneys that aren't familiar with Articles of Agreement for Deed transactions. Mm-hmm. Just in the last year, I've had to educate attorneys a couple of times on Articles of Agreement transactions where they're not familiar with it. They've just never done it before. And so, just like everybody else, attorneys are people too, believe it or not. and sometimes we're afraid of or cautious about, I think is probably a better term to use, of something we're not familiar with. So there's that fear of the unknown. And again, talking about what are the pitfalls and the risks that people take. So as an attorney, if I don't understand the transaction, how in the world am I going to explain the risks to my client, right? And so then you sometimes you get resistance on that basis from attorneys that don't understand.
Mm-hmm. Makes sense.
So again, that's something whatever I've been blessed with. Having to figure these things out and working with people who have had obviously more experience than I did when I started out, et cetera. And I think in some respect, there was some good, honest, hard work to understand them and work things out. So now in understanding those transactions, then, I have a reasonable basis to advise people who are going to be interested in that. Personally, I would recommend that type of transaction more than a subject to transaction.
Sure. For
that, everything. I think it gives people most of the benefit and alleviates quite a lot of the downside.
Okay.
To that, whatever. And certainly there's an opportunity, whatever, for, an investor to get in there, do that. Because, if you take title to, you're not going to take title to the property on an Articles of Agreement for Deed transaction, but you're going to take possession of it. If the Articles of Agreement for Deed transaction is drafted properly, that means that you've got a right to let or sublet the property, to contract for it, etc. Certainly there will be restrictions on whether or not another transaction, for example, could be recorded at the recorder's office of the county. We think you're not allowed to do that. But there's no reason, if there is full and fair disclosure, that an investor wouldn't be able to get into that transaction, and I do them on a fairly regular basis.
Great.
It's a matter of whether or not you can, you as an investor can put the right seller and the right buyer together.
Sure.
That's what an investor does most of the
Yep.
time, right? I find the right property, figure out the right strategy to pursue, and then go from there, whether it's rehab or, buy and hold or
exit
wholesale
strategy.
or whatever. Yeah,
Yeah,
you gotta
have the right exit
gotta have
strategy.
that down.
Right.
So.
Well, we're going to take a quick commercial break for a shameless plug on the Investor Empowerment Series meetup. Chris Emerald is one of our sponsors. That's the attorney speaking with us today, Chris Emerald from CE Law. Actually, has been sponsoring the Investor Empowerment Series meetup in Schaumburg, Illinois for the last year. He is available at each meeting. So if anyone has any additional questions beyond what they're hearing today, which I'm sure it's going to raise some questions because he's talking about a lot of important stuff for all types of transactions. I mean, we just dived into a topic that I don't hear much about, and I think is not something that's well publicized in the real estate investor, media type market that's out there. Chris has been a sponsor for a year at our meetup, and you can find out when we're meeting at www.investor-empowerment-chicago.com for any of our meetups that we hold. We host them once a month in the Schaumburg, Illinois area, as well as we have a couple little ancillary meetups throughout the year that include fix and flip tours of projects that I'm currently working on or some of the investors that I work with are working on. So please visit that website if you'd like more information on how to get a hold of Chris, which we will, of course, give his contact information at the end of the show. But I'd like to bring that out there for anyone who wants to attend one of the meetups and talk to him in person. We're back from commercial break. Again, back here with Chris Emerald from CE Law on the Investor Empowerment Series radio show, episode number 22. All right, Chris, so we touched on it. We digressed. We talked about a lot of good stuff, which I love. Well, let's get back to, let's go full circle and talk about asset protection as a real estate investor.
Okay. As far as asset protection for investors go, this really ties into it. Being a real estate investor is just a different type of business and industry. So this applies kind of across the board. Asset protection is something that I approach, and other attorneys, whatever, that I have spoken with, and all the seminars that I've gone to, things like that. It's a total comprehensive approach. As a business person, a lot of times what people don't understand when they become investors is that this is a business.
I love this. I love it. Keep going. Awesome.
And so they will be attracted to becoming a real estate investor for the purposes of changing their lifestyle, right, or achieving certain goals. And they have some goal in their head where somebody has proposed to them that they too can be successful as a real estate investor if they would only become part of a networking group, or if they would purchase such and such program or whatever. And what they need is education and all the rest of that. All of those things are fine within the context of an investor understanding what they're doing is engaging in a business in an industry. Mm-hmm. So typically when I speak with new investors, I encourage them to create some form of business plan, set some goals. What is the purpose of what I'm doing? How do I define success? Those kind of things. And so again, I think that's a little bit different approach than I see other attorneys, or at least I have been told, whatever, that approach is a little bit different than other attorneys. Because, look, I could deal with people that call on the phone or email me all day long and say, look, I need you to do X for me. And for that, I will charge Y dollars.
that being said, what's the real purpose and why you want to do that? So, if you become a real estate investor, are you going to just be Joe Mueller, real estate investor, and you're out there operating, and you're going to have cards printed up with Joe Mueller and your personal cell phone number on it?
And I buy houses.
Yeah, and I buy houses. Or you're just going to be that guy that runs around in the middle of the night stapling, bandit signs to telephone poles and things like that.
Bandit signs.
Yeah,
Love bandit signs.
Exactly, whatever. It's like, I don't know. Anything that you have to do out of the eyes of the local authorities, it's something that I question.
Sure.
And God bless anybody that does it. And I'm sure there are people who are very, very successful at it. There are certain lines, whatever, that even I as an attorney won't cross. I think that's one of them. But that being said, the issue is, how are you going to operate? Are you going to decide whether you're just going to be Joe Mueller on your own? And are you going to eventually get to a point where you want to form a business entity? Are you going to do that sooner rather than later? What's the purpose of forming the business entity? What do you think the benefits are for having some form of business entity? There are a lot of issues within the that umbrella of do I or don't I. So is it possible for you to just be Joe Mueller and have cell phone will invest? Yeah, I mean you can do that. There's a lot of potential liability and risk out there.
Right.
That being said, I see people that do it and they're successful at it. If that's what you're comfortable with, that's fine. That gets back to my argument before, that if you are well informed and you understand and accept the risk, then that's fine. That's what fits for you. Typically, we attorneys will propound the benefits of forming some form of business entity for investing in real estate.
Okay.
So that includes whether or not you're going to be a wholesaler or engage in subject to or articles of agreement for deed transactions, whether or not you're going to buy fix and flip properties, or whether or not you're going to buy and hold them. Now, I personally, wherever I'm of the opinion that working with a good accountant and taking their advice and a good attorney's advice is beneficial, in that your accountant may know you and your finances and recommend a particular type of entity for you. I may have a different opinion, and the truth may be somewhere in between. Mm-hmm. Again, this is all about mitigating risk and making choices. So, if left to my own devices, certainly, limited liability companies are a great tool for organizing business in the country, throughout the country. Illinois, certainly. The other typical option is going to be, a subchapter S corporation is your two main choices that most people will have. And they're both good for different things. In Illinois, I particularly find, the Illinois franchise taxes and filing fees, stuff like that, may put people off a little bit because it is more expensive for a limited liability company, both to organize and to maintain.
Right.
I guess my point is, Illinois is broke anyway, so you might...
Oh, dude, I love it.
So, it's a couple $100 to them. But that being said, I guess the other opinion that I would have is if $250, $300, $400 is the difference between making a decision or not making a decision, or whether or not you would choose one entity over another over a year's time, or at the outset of becoming an investor, when you pull the trigger and decide that you're going to form a business entity, if that amount of money is the determining factor, then I question how profitable you think that being a real estate investor will actually be.
Sure.
I mean, in the grand scheme of things, a couple, $200, $300, $400, $500 a year is de minimis as far as what you should be able to realize as a real estate investor. And if we think about that, if it's $500 over 12 months, do the math. How much is that a month?
Right.
It's less than $5 a month. I mean, really. I mean, it's the difference. At least I think if I do my math correctly, versus another way of doing things. But that being said, it's a minimal amount of money in the grand scheme of things. So choose what's best for you, not what's cheapest.
Sure.
Right? So all that being said, we can get into other topics about, different organizations or whatever will tell you that you need to form an entity in a different state and all the rest of that. And my opinion is, look,
the Wyoming LLC.
Oh my gosh, yeah. So that being said, or whatever, you can form an entity in Wyoming or Nevada or whatever you want to do, and my advice is do your homework if you're going to be operating in any other jurisdiction other than where the company is domiciled. You better know what your obligations are. In Illinois, there is a loophole that's not really a loophole, but a provision in the law that says if all you do is own property and do nothing else, that you don't have to register in Illinois as a foreign entity, and that means that you don't have to operate here, right? Or you don't have to register here. If you're doing anything other than that, then you run the risk of crossing the line and not operating correctly. So a lot of this asset protection, everything that we're talking about is what happens if something goes wrong, right? If nothing ever goes wrong in your life, God bless you, whatever, I want to meet you and shake your hand, hopefully or whatever, a little bit of it rubs off, right? Because this is just not the way that life works, whatever, things go wrong in life. Right. So the asset protection, that's part of it. That's the planning for what happens if something goes wrong. That being said, we'll ask you the question, what's going to happen, when something goes wrong? And there are plenty of things that can go wrong. For example, you could buy a property and find out that there's a defect on the title, and the title insurance company doesn't want to cover it. You can find out that you bought a property and Illinois Department of Transportation is going to, take up the first 25, 30 feet of your property.
Real life.
Put a 4-lane highway through it, right?
Yep.
I had
my house.
I had a client way back when I was a youngin' and opened up a sandwich shop.
Okay.
2 months after they opened up the sandwich shop, the town, IDOT came in, tore up the street, tore up the sidewalk, whatever, for a good, year or better. Mm-hmm. The sandwich shop didn't survive. Let's just put it. Very, very restricted pedestrian traffic and traffic to get in and out of, the parking lots and everything. Whatever. It's whatever, within the first year, 15 months, 18 months of opening a business, whatever, who can get to me? And my business isn't going to survive.
Right.
So that being said, did you not know about that? You don't know. That's not necessarily a title issue or anything else like that. That's doing some due diligence on the property and knowing what you're getting it for. That transaction might have been perfectly fine for someone, my client to have gotten into, provided that the price was right. Right? What's the old realtors saying? Whatever, I never been a property I didn't like, just a price. Whether or not the price is right. Right. Yeah, it all depends on what you pay for it. What's the value to you and whether or not you can realize the value to you. That being said, the asset protection turns into what happens when something goes wrong. So I view asset protection as kind of a layering, separating an investor or a client from ultimate personal liability in layers. So, first and foremost, is there a business entity that provides limited liability? Okay. Does that business entity maintain proper business liability insurance? Okay. What business does it conduct? Does it own properties? Does it have the proper coverages in place for the properties that it owns or not? Does it have potentially, an umbrella policy for the business that says, each property is covered, and then the umbrella policy would cover everything else? And I'm certainly not an insurance salesperson,
Right.
and an expert or whatever. And this is where all the different experts come together to advise you on, as an investor, on what you need and what choices you're making.
But a huge point that we need to, regroup and touch on is an entity is not the ultimate protection. I mean, you need to have, whether you have an LLC or an S corp or whatever you have as far as your business, you need to have insurance because that's essentially the first line of defense.
Correct.
Right?
Correct. Yeah, just because you form a business entity doesn't mean that you can do whatever you want, and that you're protected. No one can touch me.
Right.
That's just not the case. Especially for the fact, that if you're a small business entity, your ability, in some respect, to preserve the limitation of liability depends on your ability to pay for potentially an attorney to defend that.
Right.
Right. And so, while the law may be on your side, depending on what the facts and circumstances of any claim may be against the company, it's not a blanket protection. It's also not a blanket protection, for example, the principal or an officer or agent of a company to do something malicious or fraudulent, etc. Okay? Mm-hmm. Because you ultimately committed that act, and so you can't necessarily just hide behind the company 100%.
Right.
There's always something that you've got to be worried about if you personally are the one who's acting. This ties perfectly into the, that Wyoming LLC, whatever, that I'm sure lots and lots of people have been out there and heard about. If you're the one that's acting within a particular state or jurisdiction, and we'll just take Illinois, and you're actually doing things in Illinois, then you have to register in Illinois. I've mentioned that before.
Right.
But what you get into then is who's authorized to act and bind the company, what representations are made, everything. So it becomes a fairly complex issue. And I don't want to get down, too much down the rabbit hole on, whether or not somebody represents themselves as being able to bind the company and all the rest of that, everything. Because
that's why you hire an attorney,
right? Those are issues, for law school lectures and all that, and but you have to deal with those things, and as Joe says, then that's why you're dealing with an attorney on protecting you.
Sure.
But again, Joe's absolutely correct that a business liability policy is ultimately your first line of defense. As long as you're acting within, the scope of what the policy, says is covered, then the insurance company has an obligation to defend a claim. Okay? So there's your first line of defense. Then what you're doing with the business entity is protecting your personal assets from any claims for doing that. It also provides a separation for you're operating independently of your own Social Security number.
Right.
So if you're worried about identity theft and all the rest of that,
sure,
okay, then you're not potentially giving out your Social Security number. Or if you're smart enough and you go out and get a sole proprietorship EIN number, then you would operate under that. But the sole proprietorship, then you're 100% liable for anything that you've got.
And that's almost like
that's the least
right
advantageous, least desirable set of circumstances. That Joe Mueller is out there, you're doing whatever, and if Joe Mueller does something bad, and I'm not talking about malicious or fraudulent or anything like that, but if Joe Mueller is responsible for something, then you get an issue because you're 100% liable.
Right.
It just is what it is.
So as a sole proprietor or as an investor, let's take it from the basics, because we're already about an hour into the podcast, and I'm sure a lot of the questions that are going to come up is like LLC versus S Corp, which you mentioned, and now you're talking about sole proprietor. So, just to file as a sole proprietor, what's required if I'm Joe Mueller and I want to do a couple real estate deals, and I'm not sure if I want to do this full time or I want to get into this as my career yet, but I've got an opportunity or two.
Well, as a sole proprietor, you can apply for a sole proprietorship EIN number,
right?
With the IRS.
When you say sole proprietor, though, is that a separate filing like an LLC would be, or is that just hey now you're?
Well, it essentially obligates you whatever for paying taxes and reporting things, profits, losses, etc., and you use a different tax ID number, that sole proprietorship number. Ultimately, you're going to have tax liability come back to you as an individual because you're the owner.
Right.
Okay. And as a sole proprietorship, you're the only owner. Only you can own you. So
do you file that though with like the state?
Yeah. Your sole proprietorship.
Yeah. That's my question.
Yeah.
So
and different states and jurisdictions, whatever, will have different requirements.
Okay.
Okay. So you just have to pay attention. Me giving you any specific requirement is going to be jurisdiction specific. So for the state and stuff like that. So, for example, S corporations in Illinois, they're supposed to file documents with the county in which they're organized, in which their principal offices are at.
Right.
S corporations are.
Sure.
Things like that. Whatever. So and it's different for different entities and such.
But more reason to hire a knowledgeable attorney.
Correct, and work it out and make sure that you're dotting your I's and crossing your T's.
Right.
For that. But again, getting on the asset protection, again, this is, how many layers of the onion are we peeling back? How many layers of, insulation can you put between you individually, what you have, and the whoever could be a claimant? So, great examples of that are, I own an apartment building. Mm-hmm. Right? Or Joe Mueller owns an apartment building. So Joe Mueller, or you, Joe Mueller, own an apartment building. It's a 4-flat, and you've got 4 tenants in there. Okay, fully leased. You're chugging along, and you're making your cash flow every month,
right?
And everything. And one of the tenants decides whatever they're going to have a holiday party, right? So we'll cut to the chase, whatever, and there is the slip and fall, right?
Okay.
So one of the guests gets completely, intoxicated, slips and falls. And all of a sudden, they're blaming you because you, as the property owner, didn't maintain the sidewalk.
Salt the sidewalk.
So you didn't shovel and salt the sidewalk, whatever. And so now, you owe me hundreds of thousands of dollars. Okay. So if Joe Mueller is the one who owns the property, and Joe Mueller is the one who collects the rent, and Joe Mueller is the one who manages the property and signs the leases, etc. Joe Mueller is the one that's completely responsible for that, right?
That makes sense, yeah.
Okay, so if Joe Mueller forms an S corporation or a limited liability company, and that's who owns the title to that property, and Joe Mueller hires a property manager who vets the tenants and who vets and engages maintenance company to plow the driveway and the parking lot, and shovel the sidewalk and the salt the sidewalk, everything. Now there's a layer of protection where that entity that owns the property can say, we were a reasonable landlord, we're a reasonable owner. So
right.
I, Joe Mueller, should not be personally liable for actions just because I own the property. It's not going to prevent you from necessarily being sued.
Right.
Okay? The question is, who's ultimately going to pay for potential claim or settlement. So, and this is where I like to say, that the ultimate goal for any investor, that wants, for example, a rental portfolio, is to have all that be passive. Mm-hmm. It's a passive activity. The Joe Mueller who owns the company that hires the property manager who hires the property maintenance company, and they're the ones that are collecting the rent and all the rest of that, and all Joe does is
cash the check.
That's the holy grail. of the investor, at least from the investor's perspective, because you're not getting the call at 2 o'clock in the morning that the toilet is stopped up. You're not having the client or the tenant call you on, the 5th of the month trying to give you a sob story about why they can't pay the rent this month and all the rest of that. You've got other people that are doing it. And when you are a completely passive investor and you're just the owner and you've got a decent insurance policy in place and you can demonstrate to your insurance company that you've hired a responsible property manager, etc., that the coverages are going to overlap and that there are that many more layers of
Sure.
insulation for you as an asset protection.
And that's not even getting into the fact that whoever you're working with as an investor, whether they are insured, when you hire somebody to be a property manager or a contractor that's doing work on a property,
Of course.
that's not even addressing the fact that whether or not they're insured, which we could literally fill up a couple hours probably educating the world here on who to hire, why, and what type of protection you need to establish, and what insurances need to be happening.
Yeah, of course. And, Illinois is a jurisdiction, certainly you've got to worry about and why you want to be mindful, what type of insurances you buy, if you buy a property, if you're rehabbing it versus you just own it, and all the rest of it. But again, that's way beyond the scope of our little podcast here today. That being said, whatever, what the investor needs to take away from the podcast, if they get something on this particular topic, is that, there isn't a silver bullet for asset protection. Mm-hmm. It's at least from my perspective, it's a layered approach that needs to be implemented and followed through on. And if you're not willing to do that, then again, getting back to my theme, if you're not willing to do that, understand the risks that you're taking. And if those risks are acceptable to you, then that's okay. But understand the risks that you're taking.
But how does somebody actually determine that?
Well, you mean this is the consulting with the attorney and the insurance professional about what they need, which is a great point about choosing a decent insurance professional.
Sure.
I can tell you many, many stories about the investor that goes to the broker that sold them their personal home insurance and said, here, I want an insurance policy on such and such property, and thought that they were going to cut corners on premium or whatever by not telling them exactly what was going to go on the property or whatever it's going to be. And then finding out at some point in the future when something bad happens that they don't have coverage for that.
Right.
Okay.
Right.
Because, not to vilify insurance companies, but to vilify insurance companies, they're in the business of collecting premiums and denying claims. Okay, and that's a horrible statement to make about them or whatever. But if the facts and circumstances of what happened on your property aren't covered because you decided that you didn't want to pay for a rider or whatever, if that's what happened to you, and they can legitimately deny your claim, that's what they're going to do.
Right.
And if you decide that you're not going to tell them about something, that's a perfect example of, because you didn't tell them, you didn't even give the insurance professional the opportunity to offer you the correct coverage.
Right.
So it's not really their fault.
Yeah.
It's the investor's fault for thinking that they're going to be smart. Because if I tell them what I'm really going to do with the property or what's going to be going on with the property or whatever they think that they're going to be clever about so they can save an insurance premium, and you don't have the right coverage, then there's no point in having the coverage.
Right.
Right? I mean, and again, this is all, it's risk mitigation.
Right.
But that's fine. Okay, so I've got a property covered for fire and theft and vandalism or whatever, but I'm rehabbing the property, and I don't have coverage on the property to say that, if one of my subcontractors who's working on the property gets hurt and they don't have workman's comp insurance, then I, as the owner, the property, am ultimately responsible. But I decided I didn't want to pay for workman's comp insurance. Well, that means that you're going to have liability.
Right.
You know, and so those are all great things. You know, if when you're an investor and you're doing the spreadsheets and you're figuring out, you know, what's my profit margin, right, my return on my investment, or whatever, you know, that you're doing with it to justify the investment, or figuring out what you expect to make on it, then what happens when that $50 or $100 a month rider that you didn't buy, right? Because you decided not to tell the insurance professional that this is what was really going on, whatever. And that's exactly what happens. Again, we talked about the fact that whatever life happens, people, you know, we wouldn't have to worry about any kind of asset protection, whatever, if nothing ever went bad, if nothing ever went wrong in life. You know, it's just not the way that life works. So what my experience typically is to plan for the things that you can, and the one thing that's going to get somebody is what they decided to either ignore or didn't understand. Right? It's just a matter of how comprehensive that you can be with that. And, you know, the person who is more prepared, etc., then their risk gets smaller and smaller and smaller.
Sure.
And at that point, then, you know, there are certain risks, whatever we have to take. Nobody's going to completely insulate either themselves 100%. You know, I think that's impractical. You know, and this is a risk-reward kind of endeavor, right? So, to engage in, you know, another method of analysis would be a cost-benefit analysis. If I pay this much, whatever, for insurance, I'm covered for these things. If I pay a little bit more, I'm covered for these things. Then we start looking at, if I want to have all the coverages, you know, for that little tiny thing, whatever that can happen, then my insurance premium is going to be thousands of dollars a month, or whatever. What's the likelihood of that happening? Life and business, or whatever, are all about risk management. In risk mitigation. So you understand your risk, whatever you take, what risk you feel comfortable with, and insure against the rest for that.
But as an investor, I think, I mean, one of the key points that you're hitting home about is, we'll just take the insurance side. You need to explain to the insurance broker or whoever you work with on a day-to-day level, whether you're just getting started or you're an experienced investor, exactly what your plan is with a property. And I say that, like, I'm not saying, like, you know, fix and flip, buy it on day one, sell it on day 30, but that would include that. I'm saying insurance brokers are in the business of making money and selling you policies to get the premium so they can make money, right? So shame on you if you have not explained to your insurance company of choice what exactly your plan is with one of these assets that you're planning on flipping or holding as a rental or whatever, because I guarantee you they're not going to turn down the opportunity to take on more risk on your behalf if they're going to make more money on it. And when I say that, I mean, if you're flipping a property and you are gutting it down to the studs and you've got 10 guys working in there every other day, there's probably a different type of policy, maybe like a builder's risk, as opposed to something where you're just going to own the property and it doesn't need any work and you've purchased it at market value and you're just going to throw a tenant in there. So for the investors out there listening, I mean, basically what I'm saying, and I think Chris is touching on and elaborating on, is the fact that you got to be honest with the people that you're working with in this industry. You got to be honest with your insurance guy and your attorney, which he also mentioned, so they can establish the right type of protection that you need on the asset protection level in order to, you know, make sure you're adequately covered. And there's no end-all, be-all, is what you're saying, Chris, right?
Sure.
I mean,
sure.
there's always that opportunity to get to. And you know what? I'm going to digress just for a minute on my own experiences. As a real estate broker, I had an experience this year in 2016 where I brokered a property that was listed by myself, owned by a bank, one of the larger, you know, well, I don't think it matters who I say it, who it is, but Fannie Mae owned a property in Illinois. I listed it as an REO, so it's bank owned. Fannie Mae owns the property. Last year, 2015, when I found a buyer for it, and it was cold. It's Illinois here, it's Chicago, cold, windy, rainy, whatever. We get a buyer, he closes on the property I think on December 15th or so of 2015, and immediately thereafter, apparently the property needed a roof. He hired a roofer to go replace the roof or repair it, I'm not even sure, and the roofer that this buyer hired, which I was not representing on the buy side, so I'm working for the bank, I'm working for Fannie Mae. The buyer comes to the table from one of the other brokers that works with us in Illinois, Coldwell Bank or whatever. I'm not calling any names, and I'm not supporting their companies either. But so the buyer closes the deal on December 15th. At that point, Joe Mueller is out of the picture. We sell the property. I'm done. Check comes, HUDs, all that stuff. Money's dispersed. A week later, he hires a roofer to fix the roof, which, from my knowledge of the situation, I never went on the roof. I'm not a roofer. I have no idea what type of work it needed, whether or not it needed to be replaced or not. But that buyer made the choice to actually hire a roofer and fix the roof. And that roofer, unfortunately, had the unfortunate circumstance of actually falling off the roof and hurting himself. And when he hurt himself, he was incapacitated from work as a result, because he's in the hospital for a couple days, and then had some type of physical therapy type situation after the fact, because it took a while for him to get back on his feet, we'll say. Well, I was sued. About a month later, I get papers in the mail from a separate insurance company, because this roofer, who I have no affiliation with, I have no idea about, don't know what's going on, because I've got nothing to do with that transaction at that point. I've sold the property over a month ago to a new buyer, and the buyer hires the roofer. So there's nothing to do with Joe Mueller or Tanis or me. And, I was involved in litigation for several months, basically trying to explain to the court system that, well, I'm just the middleman. I list for the seller, who happens to be a bank and knows nothing about the property. We don't do roof inspections. We're not roofers. We have no knowledge of how a roof, operates, exists, gets fixed, et cetera, et cetera. And yeah, I was involved in a lawsuit for several months as a result of that, based on the fact that whether it is that the roofer needs a payday, right? He falls off the roof, he gets injured. I couldn't even tell you if he had insurance or how adequately protected the buyer of that property was, because it didn't really matter at that point. They went after whoever they could in order to create the payday that they were thinking that they were going to get. And I mean, I don't necessarily blame the guy, but at the same time, I'm completely out of this situation. All I did was act as a real estate broker selling a property to an investor. That investor, I don't know if he has insurance. I don't know if the people he hires have insurance. None of my business, none of my problem is the way I saw it. But in the end, I had to defend myself in court to basically explain to the judge that had nothing to do with me, and all I am is the guy who puts the pictures on Zillow and makes sure that the property gets sold. And I'm minimizing what a broker does, but to that fact, every investor needs to have a wherewithal and a concern over how that stuff could happen to them, because even as a wholesaler or somebody acting in a transaction, when something goes wrong in a property, whether you know about it or not, disclosed, non-disclosed, doesn't really matter, you're still potentially on the hook for what happens in the immediate future of that potential opportunity. So for everyone listening out there, I mean, we're wrapping up this podcast right now. I know we're an hour and a half in, and I just want to make sure that everyone understands that the reason why Chris is on this podcast today is because you really need to have an educated attorney who understands how the real estate investment business works and what your goal as a real estate investor is, in order to make sure that you're covered, whether it be asset protection or insurance or, the progressive opportunity that your business wants to undertake, I mean, you can't do it without somebody who knows what they're talking about. And I got to be honest, I applaud Chris Emerald. I've worked with him for several years now, and he's the only attorney that I've been able to have open conversation with about real estate investing that understands what it is. He understands what a wholesale transactions is. He understands subject to articles. I mean, all the things we talked about today. If you're not in Illinois, which I don't know, do you operate outside of Illinois? No. He's just an Illinois attorney. I shouldn't say just because he's awesome, but you got to find a guy like that to make sure you're adequately protected and that you structured your entities correctly and you've got somebody you can rely on to defend you if something comes up like this. So, I mean, I guess we're wrapping it up. But I know we can go on for a few more. I'm sure
that's a good stopping point for the things, whatever that we had discussed originally.
Absolutely. So, again, Chris, I can't thank you enough for the time you've taken today. We're doing this on November 25th, the day after Thanksgiving. He's taken time away from his friends and family to sit down with me and actually record this podcast. And I can't. Again, there's another point for anyone who's looking for somebody in the Chicago area or in Illinois in general. I mean, this guy takes time out of his own day, his personal time, in order to meet with me just to record a podcast. So, what's the best way for the listeners to get a hold of you, Chris?
Well, first of all, they're welcome to always come to the meetup.
Thank you. Yes.
Right. So hopefully I'm able to be there. Sometimes I haven't, just for the fact that trying to deal with client obligations and things like that.
Because the client comes first.
Yep, client comes first. And so for that, and so sometimes I've had to be absent. But that being said, we're obviously the meetups and coming up and saying hi. Promise not to bite, and happy to shake your hand and sit back and discuss with you. Other than that, typically you can call the office at 847-960-3070. Do my best to follow up with people as best I can. And
give us that phone number again real quick.
847-960-3070.
Okay.
And my email address is chris@celaw.net. So that's CHRIS@CELAW.net. So
awesome.
If you email me, typically I will respond to you as quickly as possible, usually within a day or so. If it's something brand new and I haven't spoken to you before, or I've just spoken to you at a meetup or some other event, be a little persistent, whatever, to make sure that I know the context of that. That's one thing. Whatever I'll say, a lot of times I'll get somebody that just calls, doesn't offer a name, a context for the call, or often even a telephone number to get back to them. Just, hey, give me a call back. Give me some context, whatever, so that when I follow up with you, I know exactly what we're
right.
What we're
so they can
the subject matter,
establish a sense of urgency if needed. Right.
Right.
Essentially.
Right.
Okay. Great. So, thank you again for all the listeners of the Investor Empowerment Series radio show. Being Thanksgiving, special thanks to all the police, firefighters, and members of the armed forces, active and retired. You want to see us again? We're on iTunes, we're on Stitcher, we're on YouTube, we're on a bunch of stuff. I don't even know where to find me, but Google it up, find it. GTS, Google that shit. Thank you again. We'll talk to you soon.
Thanks for listening to another episode of the Investor Empowerment Series radio show. Be sure to tune in next week for another empowering episode. We welcome your feedback, so please rate us on iTunes and Stitcher, and visit us at www.investorempowermentchicago.com or TannisGroupRealty.com.